Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding. We, thine unworthy servants, here gathered together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations. And grant that, we having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the king, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This honorable house now resume its sitting. I wish to welcome all to the sitting of the Honorable House of Representatives this Tuesday, January 27, 2026. As always, it's an honor and a privilege to do so. I wish to also welcome all who are visiting with us here, as well as those of you who are joining us online via the various social media platforms and PBCJ live stream. We are fortunate to have with us today 4 of our international experts. Please make welcome Ms. Lydia Buchanan, Deputy Head of Program Bilateral Engagement, CPA Headquarters. Mr. Jack Hardcastle, Good Governance Project Lead, CPA Headquarters. Ms. Seinglis Elliott, Deputy Director for Program Management and Monitoring and Evaluation at PAR Americas. Mr. Sean Kinsey, Senior Clerk, House of Commons, UK. We welcome you all. I would like to encourage all members to make every effort to attend the Commonwealth Parliamentary Association post-election seminar, which will be taking place next Wednesday. This is tomorrow, Wednesday, January 28th, through to Friday, January 30th, from 9 a.m. to 4 p.m., each day at Gordon House. This seminar promises to be a highly informative and practical, focusing on myriads of topics over the course of the 3 days. Day 1 will focus on foundation of parliamentary life. Day 2 will focus on financial scrutiny and core functions of Parliament. Day 3 will focus on the leadership, representation, and communication. We do encourage that as many as possible, if not all, of us be present. We are also privileged to welcome a distinguished group of experts from the CPA parliamentary. Oh, it is before us already. Today we pause to reflect on the life and legacy of the legendary drummer Sly Dunbar. we take it after. Call of the roll.
Mrs. Holness, Dr. Holness, Dr. Chang, Mrs. Williams, Mr. Bartlett, Ms. Grange, Dr. Tufton, Mr. Mackenzie, Mr. Montague, Mr. Vaz, Mr. Chuck, Mr. Charles Jr., Mr. Morgan, Ambassador Marks, Mr. Samuda, Dr. Wheatley, Mrs. Cuthbert Flynn, Mr. Terry Long, Mr. Whittle, Mrs. Dalrymple Philbright, Ms. Morrison, Mr. Chuck, Ms. Lee, Mr. Donovan Williams, Mr. Main, Ms. Crawford, Mr. Delroy Williams, Ms. Hamilton, Mr. Sivright, Mr. Azan, Mr. Brown, Dr. Brown-Burke, Mr. Buchanan, Mr. Bunting, Ms. Burchell, Dr. Campbell, Mr. Cousins, Mr. Crawford, Ms. Daly, Dr. Dawes, Mr. Goulding, Mr. Gordon, Mr. Hales, Mr. Hines, Mr. Hilton, Mr. Jackson, Ms. Jess, Mrs. Malahoo Fort, Mrs. Miller Bennett, Mr. Morris, Mrs. Nita Garvey, Mr. Newell, Mr. Paulwell, Mr. Phillips, Ms. Perkis, Mr. Robertson, Mr. Robinson, Dr. Russell, Ms. Shaw, Mr. Smith, Mr. Dwayne Vaz, and Mr. Warmington, Mr. Bartlett, and Mr. Sivright. Thank you, Mr. Speaker.
Statement by ministers. Announcement.
Laid on the table of the House are the following. Annual report of the SCJ Holdings Limited for the financial year 2019-2020 and its related ministry paper numbered 02 of 2026 titled Annual Report of the SCJ Holdings Limited for the financial year 2019-2020. Annual report and audited financial statements of the Jamaica Bauxite Mining Limited for the financial year 2020-2021, along with its ministry paper numbered 03 of 2026, entitled Annual Report and Audited Financial Statements of the Jamaica Bauxite Mining Limited for the financial year 2020 to 2021. Annual Report of the Land Divestment for the financial year 2022-2023. The Annual Report and Audited Financial Statements of the Coconut Industrial Board for the year ended December 31, 2022, and its related ministry paper numbered 04 of 2026, entitled Annual Report and Audited Financial Statements of the Coconut Industrial Board for the year ended December 31, 2022. And finally, the Economic and Fiscal Assessment Reports of the Independent Fiscal Commission for the financial year 2025-2026. Thank you, Mr. Speaker.
Yes, I'm inquiring, Mr. Speaker, because since Hurricane Melissa, we haven't seen any report from the Cabinet. These were reports that were normally tabled routinely arising from cabinet meetings. I haven't seen any since then, so I'm inquiring of the House Leader, when can we expect to start receiving these reports?
Thank you, Mr. Speaker. I will make my checks as to see when was the last time these reports were tabled. In my mind, some were tabled fairly recently, but it could be late last year. But I will check. I'm sure that the Cabinet Office, who I'm sure are tuned in, will ensure that we have some reports by next week. Cabinet does continue to meet, and as such, the reports normally come some weeks thereafter. So I will ensure that some reports are here by next week.
Bills brought from the Senate, petitions, papers, report from committees. Notice of motion given orally.
Mr. Speaker, I beg to give notice that at the next meeting of the House, I will move, be it resolved, with reference to the resolution approved by this Honourable House on the 28th day of January 2026, appointing a select committee of this House, which is to sit with a similar committee appointed by the Senate, to consider and report to this Honourable House on the findings of an act to facilitate the implementation of child diversion in the criminal justice system, and for connected matters, that the Honourable Delroy Chuck be appointed as a member and chair of said committee. Mr. Speaker, I further beg to give notice at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Mr. Speaker, I beg to give notice that at the next meeting of the House, I will move to introduce and have read a first time a bill shortly entitled the Registration Shared Community Act 2026. Mr. Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take the first reading of the bill.
Question and answers to questions.
Mr. Speaker, I'm seeking clarification again, because an attempt was made yesterday by a member to inquire or to submit questions to the Speaker for approval for tabling today. And it was followed by, again, a document circulated to the member, which confused the process. And I'm really hoping that we can clarify this finally. And also to be able to get a clear timeline as to when, what time during Monday, the questions must be submitted for them to be properly vetted for tabling today. Because I think it's unfair that the member having submitted the questions for vetting yesterday, the approval has not come as yet. So I'm urging that a definitive statement be made as to what time on the Monday is a cutoff time for the tabling of questions, so that we don't have a confused state of affairs going forward.
I think on this matter, the Speaker has issued clear directions in relation to the questions to be submitted. I think my recollection is within at least 24 hours before one intends to table them. But this is a process. Once the questions are tabled, then the questions, in accordance with the standing order, have to be vetted, looked at, examined by the Speaker to ensure that they are in accordance with said standing orders. We would have gone through this process already. This letter, my understanding, with the questions would have come in yesterday, and the Speaker at the time has not gotten the chance as yet to look at it, and as such, the questions are not now here with us. As we can all appreciate, the Speaker is not in the House at this time, and as such, and as And as such, based on the time when the questions arrived and the speaker not being able to peruse the questions at that time, the questions are not yet before us. I am very certain that as soon as the speaker can peruse the questions, once the questions are in keeping with the standing orders, then the questions will be so tabled at the next appropriate time.
Oh, it's my time. I think I was up before you.
The member was before you.
Mr. Speaker, the standing order says the questions are delivered before the sitting of the House. The decision was that at least 24 hours before. If a member submits his or her question 24 hours before, it's no business of the member whether the speaker look at it or not. It's supposed to be with it before the sitting. It can be 10 minutes before. It can be 10 minutes before. Okay? So if the speaker says 24 hours, the member make them available to the clerk before. Okay? If the member delivered to the clerk 24 hours before, it's not the member's fault. So we can't say the speaker didn't have the time to look at them. Why the hell did you ask for the 24 hours before? It's not the member's fault. The speaker took 24 hours, the member filled his or her obligation, so it's not our business whether or not the speaker look at it. It's our obligation to review it before. So don't tell the member this time. Don't tell the member. Don't tell the member the speaker didn't get a chance to look at it. That's not unacceptable. Totally unacceptable. And we shouldn't bring the House to that level to come with this nonsense about they get a chance to read. Nonsense.
Before you, House Leader, let me just read from the standing order.
Based on my information.
Sorry, turn the mic on.
Based on my information, the questions were submitted at 3:41 p.m. yesterday. That is my information.
Members. Before you all speak, I will be reading from the standing order as it relates to questions. Section 14, nature of question, subsection 2. Notice of a question may be handed by a member to the clerk during the period known as question time. Every such notice shall be signed by the member giving it. A member who desires an oral answer to a question shall mark his notice with an asterisk, and a question not so marked shall require a written answer, which, when received, shall be circulated with the minutes of the proceedings of the House. Subject to paragraph 5, a question mark for oral answer shall be put down for a day to be named by the member, being a day not earlier than 21 clear days after the question has appeared on the question paper. I am reading from the book, that's all.
Mr. Speaker, in adopting the position advanced earlier by the member from Southwest St. Catherine, I'd just like to say, Mr. Speaker, that anything can happen to the sitting speaker. And if we can advance now by urging the deputy speaker to also be in a position to vet these questions and to signal approval. So it need not have to wait on the substantive speaker to address these routine matters. And the section that you have read already, the section you have read, Mr. Speaker, it really is not relevant to the issue at hand. Right?
So, Mr. Speaker, I would have just gotten sight of the Speaker's ruling on this matter the last time that it came up. And what I said earlier was not a part of the Speaker's ruling in relation to the 24-hour period. What the Speaker had indicated in her ruling is that the standing orders are to be strictly adhered to. In other words, at question time, the member looking to table questions are to hand up the questions at that time. At that time, the questions, then there will be a vetting of the questions. It does not mean that the questions being handed up at this time, that the Speaker who is currently sitting in the House will be able to vet them immediately and to see if they are keeping with the standing orders. And to be clear, let me just read what was said. Standing Orders 15.2 provides us a notice of a question may be handed to the clerk during question time. So when the Speaker indicates question time, all members are reminded that strict adherence to this standing order is required to avoid confusion or conflict. So in other words, bringing it in before 24 hours, that's not the methodology, right? So, no, that's not what, this is the ruling of the Speaker. Once received by the clerk, this was this, no, when it comes to question, once received by the clerk, each question must be submitted to the Speaker to enable the discharge of the responsibilities under Standing Order 16.2. That standing order empowers the Speaker to determine whether a question infringes any standing order or constitutes an abuse of the right of questioning, and to direct the question to be amended or entered in the order book with such alterations as may be necessary. The Speaker's review ensures that the questions are properly framed, comply with the standing orders, and may be tabled in an orderly and procedurally correct manner. According to Standing Order 15.2, accordingly, Standing Order 52 does not guarantee same-day tabling. Effective immediately, questions submitted during question time under Standing Order 15.2 will be received and reviewed by the Speaker. All questions will be tabled following the completion of the Speaker's review once deemed to be in full compliance with the standing orders. The procedure safeguards the rights of members, ensures the orderly management of parliamentary business, and confirms that all questions comply with the standing orders. Members are therefore expected to comply fully with these directions. As such, we can recommit question time for the member to submit to the clerk the questions. And then the Speaker will review the questions for the questions to be in keeping with the standing orders in accordance with 15.2, and once that review is done, then the questions will be tabled. Well, let us, you have a right to table in accordance with the standing orders. So let us proceed with that standing order. Yes. That is the Speaker's ruling, isn't it? No, that's the note. Just to be clear, members, I would have said earlier, and that was incorrect. What the Speaker has indicated is what I just read. That was her ruling that in keeping with the standing orders, during question time, the questions are to be tabled, and then they'll be reviewed by the Speaker to ensure that they're in keeping with the standing orders. It's very clear. It was sent to all members.
Member from St. Catherine Southeastern.
Thank you. Mr. Speaker, having followed the logic of the leader of government business and the ruling by the Speaker, what we are doing is concentrating the powers of a gatekeeper into the hands of the Speaker. Because if you submit something and the Speaker decides that it's going to take 2 weeks, 3 weeks, 4 weeks, 3 weeks, 4 weeks, we can end up in a situation where the tabling of the questions will be delayed until the matter is no longer relevant. Now, where did this 24 hours come from? And why is it that we were referring to 24 hours and then the pushback to say that it was late by half an hour no longer stood? We're hearing now that it is going to be tabled during question time, and at the discretion of the Speaker, maybe this year the questions will be deemed appropriate.
Member, the ruling from the Speaker was from last December. So pay attention to that. It was from last December. So it's not just now. It has been here for at least a month or so.
Mr. Speaker, I rise simply for clarity. I was actually in the House one Tuesday afternoon when the Speaker made a big point about making sure that the questions came in time before. Yes, I was sitting here. No one told me. I heard it with my own 2 ears. In fact, the point that you have raised was the point a member sought to make. And he was made to seem as if he was ignorant to the standing orders. In fact, the Speaker did say that he should know better because he had been here before. And so I do not want us to just run across it like that and pretend that the Speaker did not give us different instructions separate to the note that she has written. In fact, if you just allow me, I'm ending now. In fact, the problem has been that in trying to keep order, sometimes the Speaker goes beyond, yes, what she is supposed to. And I think that just a little discretion and treating us as adults to listen to the points that we are making in that conversation could assist.
Mr. Speaker, you know, I'll start with the last point made by the member. One of the challenges that we've had in this House is probably that point about discretion. What the Speaker has consistently tried to do is to keep us in line with the standing orders. It doesn't have to do with treating anybody like children, but we are a parliament of rules, and the rules are contained in the standing orders. And if as adults we do not like the rules, if as adults we do not like the rules, we do not chastise the person who is keeping the rules. We use the processes to amend the rules. So it is very important that we do not misrepresent the approach of the Speaker. And the beauty with this Speaker, other than indicating her view, is that the Speaker reduces to writing in very clear terms her position and rulings on matters. And what she does is to consult and then to issue a ruling. So on the 2nd day of December, 2025, under Speaker's ruling on the House of Parliament documentation, the Speaker has a very clear ruling. So I ask all the members to familiarize themselves with the ruling. Secondly, to the member from St. Catherine, the standing orders does make the Speaker the gatekeeper. It is very clear. Standing Order 16 says, the 16.1 says, the right to ask a question shall be subject to the following general rules, as to the interpretation of which the Speaker shall be the sole judge. There's only one Speaker, and the Speaker has to be that judge. So again, to be clear, and I apologize to the House earlier in relation to not first consulting with the Speaker's very clear ruling. To be clear, when the House reaches the agenda item, question time, the member who is desirous of asking questions are to submit their questions to the clerk. The clerk will work with the Speaker in relation to the review of those questions. I appreciate the questions about time frame. It's one of the issues that the standing order is silent on. However, I am very sure, especially whether it be the Deputy Speaker or the Speaker, that it will be done in reasonable time. Reasonable is a construct of law. Reasonable time. Reasonable has to be depending on the questions. Whether, remember, the Speaker is going to assess whether the questions fit in to the rules. So it depends. Member Bunting asked about 30 questions, 35 maybe, under different categories. You understand? So I understand everybody. There is no attempt to frustrate. It's an attempt to put a system in place. Let's stick with the standing orders. Speaker.
Question and answers.
Mr.
Questions.
Speaker.
Questions and answers to questions.
Mr. Speaker, I had indicated long ago on the mic, my mic has been on. That's why I'm catching his eye now. A mic has been on before the leader spoke.
Member from St. Catherine Southern, go ahead.
First, I want the removal of the member from Western Kingston. Mr. Speaker. Mr. Speaker, the matter of the rulings of the Speaker in recent times have become very controversial. And it is unusual. It is unusual. The standing order in number 72, Privileges Committee of Parliament. The standing order allows for the rules that govern the operations, the privileges be settled.
Let me hear the point of order. Turn your mic on, please.
I think it's very inappropriate to be discussing a matter involving the Speaker in the absence of the Speaker. And furthermore, and furthermore, Mr. Speaker, to question the standing orders on which the Parliament is operating. Mr. Speaker, I believe It is a point of order. It is a point of order.
Continue
And
with
the
the point.
members are using this for grandstanding. The grandstanding. And you should not allow it, Mr. Speaker. You should not. Not yet.
My mic was on. Okay.
Members, if you continue to have the crosstalk, then we will just continue with the business of the House. I gave you the floor, and you started to make some comments, which is no way in keeping with the standing order that you're raising on. Understand? Please. No, you don't have to respond to my comment. You stand on the ground to make a statement. Go ahead quickly with it. So, all right, so we can move on then because you weren't making a statement.
Mr. Speaker. Mr. Speaker.
Member from St. Catherine Southern, you have the floor.
Mr. Speaker. Hold on, Faith. Hold on, Faith. Mr. Speaker, Faith. Hold on.
Member from St. Catherine, so sit.
Turn his mic on.
I will say this. When I asked a member to sit a while ago, I asked a member from St. Catherine Southern to sit because his mic from... I was asking the member whose mic was on to sit so I could address you. But you continue to shout across the floor. I am saying to you, your mic was on, and before you could even start to make your presentation, you were cross-talking with another member. You did. I am going to ask you, member. I am going to ask you to sit now. I am going to ask you to sit. Member from St. Catherine Southwestern. I am ruling on this. I am asking the member from St. Catherine Southwestern. Your mic is lighted up and I'm going to turn it on now. You are the person who have the floor.
No, Mr. Speaker. No.
Hold on.
Mr. Speaker, my mic is
Mr.
on now and
Speaker.
I will speak.
Faith.
My mic is on now.
The only reason you're behaving in that manner now, I simply gave you the floor. All you did was I'm giving the person next to speak, and he is going to speak. Member from St. Catherine South. Member from St. Catherine South. I'm attack.
Thank you. Mr. Speaker, all I wish to say at the outset, one, rulings from the chair, from the Speaker's chair, have been most controversial in recent times. This Parliament have seen speakers from both sides. It has never happened before. We have never had these levels of controversies about the Speaker's ruling. They have been easily adhered to by either side. We have walked that road before. The Privileges Committee in the Parliament sets out a way to arrive at a consensus around how the House's business are conducted. It is not for the Speaker to unilaterally, arbitrarily set rules on the running of the House. And there's a reason for that, Mr. Speaker. The Parliament will change from time to time. And whichever side is in government is expected to abide by the commonly agreed rules. And it's for that reason why the rules in the House ought to be arrived at through consensus on both sides. Not by the opposition by itself, and neither by the government. It's a parliament of members. And all we're asking for, the rules that will obtain as it regards to questions or any other matters, private members' motion, how they are dealt with procedurally, they be settled there. The ruling of the Speaker as an umpire is to ensure that the decision of the moment when the House is in session is in keeping with those agreed provisions. Now, Mays, that is not a standing order, is recognized because it says both sides must agree. So even if the standing order is not explicit on a particular point, there is nonetheless an agreed way in which those matters are dealt with. Mr. Speaker, I respectfully and humbly submit. Yes. If we continue with that convention, which has not been controversial before, we won't have much of the problems that we're having in the House. And for heaven's sake, we don't want posterity to judge the tenure of this House in a very unfavorable way. So I make a plea. Let us just revert to an orderly, balanced way of how the House business is conducted. I have, lastly, before I take my seat, I have in the past Parliament prepared questions, submitted them before time, and it's 1.5 months before they're able to end up reaching here. I've been on the receiving end myself, which has not been in keeping with the conventions of the Parliament. So I make my plea, Mr. Speaker. Thank you.
Mr. Speaker, the House Leader make reference to ruling by the Speaker. You read section of the standing order. But may I draw the House's attention to the fact that the Speaker's ruling cannot be in conflict with the standing orders. And if such rulings are in conflict with the standing order supersedes any ruling from any Speaker.
Oh, you saying something?
Mr. Speaker, I just wanted to add my concern to the conversation because I don't know if I'm hearing something differently, but it's coming across from what I've heard, member said from St. Catherine South, as if the speaker is on a frolic of her own, as if she's doing, no, let me finish, please. And that is not my experience, and that's not what I heard the House leader read. The House leader read the ruling of the Speaker, which from listening to it, the Speaker's ruling was consistent with the standing order. So member from St. Catherine South, if you're asking the Speaker to be consistent with the standing order, then the ruling of the Speaker is proper. Her action in relation to questions being posed or tabled is in line, is consistent. To ask her, the Speaker, not to do that would be asking her to be inconsistent with the standing order. So I just want to make the point very clearly, Mr. Speaker. Let us not paint the picture that the Speaker is operating in a manner that's not consistent with the standing order, because that's not true. That's not true. The Speaker, the ruling is very clear, it is consistent with the standing order.
So, Mr. Speaker, I think the member from Clarendon Central was on point in relation to his framing of it, and also the member from St. Catherine Southwestern, that whatever the Speaker rules has to be in accordance with the standing order. There has been no controversial ruling by the Speaker, and it is unfortunate. It is unfortunate. It is unfortunate that it is framed like that. There may be rulings that people don't agree with. That is that doesn't rise to controversy, right? No. On this matter, the member from St. Catherine South is correct. You only go to Mays for interpretation if the provision is not clear. There is no lack of clarity in relation to these provisions. The challenge is that they have not been adhered to over the years. This Speaker is saying we are adhering to the standing order, and that will benefit every member of the House. As the member from Manchester Southern tabled these questions, would have been answered in the time were it not for I couldn't be here that day, and he got it the next time at bat. The member from St. Catherine Southwestern has moved his private member's motion. They have been debated in keeping with the standing order. The member from St. Catherine Southwestern, you don't have to get up. I'm talking now. I'm talking now. Don't tell me about that. I'm talking now. What I'm saying, we are adhering to the standing orders. Thank you.
Motion that may be made at the commencement of the public business requiring notice. Motion relating to the sitting of the House. Motion for leave to introduce bills. Presentation of bills without leave of the House first obtained.
Mr. Speaker, I now move for the suspension of the standing orders to enable me to take the first reading of a bill shortly entitled the Registration and Shared Community Act 2026.
Members, the question is that the standing order be suspended to allow the minister to take the first reading of the bill. Those in favor? Aye. Those against? The ayes have it.
Thank you very much, Mr. Speaker. And let me also thank my colleagues. Mr. Speaker, I now move that a bill shortly entitled the Registration Shared Community Act 2026 be read a first time.
Mr. Speaker, thank you. On this particular motion, I represent a constituency that probably has the largest number of gated communities in the entire country. I had a very cursory look at the bill. It has very far-reaching implications for how those gated communities operate, legally and otherwise. I believe it is in the best interest of the Parliament and the country for a bill like this, which is being introduced for the first time, to be referred to a joint select committee where you can have stakeholders review it, give their comments before going through this process. So I'm not here to comment on the substantive nature of the bill, but to recommend that it be referred to a joint select committee.
Mr. Speaker, I have heard the gentleman. We are just having the bill read a first time. The member, my apologies. We are just moving to have the bill read a first time, and we're not going through the conclusion.
So we'll take the first reading.
And we will, as always, this government and this side always consult with stakeholders, always.
A bill shortly entitled the Registration Shared Community Act 2026 is read a first time.
We'll take the second reading. Notice.
Mr. Speaker, I beg to give notice of a second reading of the bill. Thank you.
Public business. Public business.
Public business.
Mr. Speaker, we are going to go into public business, but I would ask for the recommittal of questions and answers to questions.
Question and answer to questions. Come. So, sorry, member. We're asking that the question, the recommittal, those in favor, those against, the ayes have it. Member.
Thank you, Mr. Speaker.
Public business.
Thank you. Thank you, Mr. Speaker. In public business today, we will have the commencement of the debate on the amendment of the Cybercrimes Act, and that will be piloted by Minister Andrew Wheatley. And we will start with that, Mr. Speaker.
Member from St. Catherine, South Central.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise today to open the debate on the bill shortly entitled the Cybercrimes Amendment Act 2026. Mr. Speaker, this debate is timely because Jamaicans' daily life is now unavoidably digital. Our commerce, Mr. Speaker, is digital. Our relationships are digital. Our public discourse is digital. And, Mr. Speaker, increasingly, the dangers and pitfalls are digital. Mr. Speaker, if we look at what is amplified by social media virality, remote anonymity, cross-border criminal networks, and now, Mr. Speaker, artificial intelligence that can generate convincing deepfakes, synthetic voices, and manipulated imagery. Mr. Speaker, the modern criminal does not need to be in the same parish or even the same hemisphere to target a Jamaican citizen. Mr. Speaker, one click can cross every border our laws were never designed to stop. Mr. Speaker, our cybercrime framework was created to meet a specific reality, and it has had to evolve over the years, Mr. Speaker, as the reality evolved. It was designed, Mr. Speaker, in an era when cybercrime was often understood narrowly as the unauthorized access, interference with systems, and the misuse of devices. Today, the threat picture is wider and sharper, Mr. Speaker. Identity theft are at scale. Financial fraud and payment diversions are now common assault. Harassment and extortion conducted through viral platforms and reputational destruction through synthetic media that can, Mr. Speaker, fabricate a person's likeness or voice with alarming realism is now the order of the day. Yes. Mr. Speaker, in keeping with the intent that our law must keep pace with technology, a joint select committee was established under Section 25 of the Cybercrimes Act to review the Act. And, Mr. Speaker, it reported this Honourable House in May of 2023. The bill I tabled last week, Mr. Speaker, gives effect to those recommendations and the policy decisions flowing from them. Mr. Speaker, this amendment package is about three things: stronger protection for people, especially our children and most vulnerable, Mr. Speaker; sharper tools for law enforcement and prosecutors; and of course, Mr. Speaker, in an ever-evolving landscape, updated definitions and offenses that reflect how harm now travels through digital platforms. Mr. Speaker, I will now take the House through the bill clause by clause. Mr. Speaker, Clause 1, which is the short title and construction, establishes the short title of the bill, that is, the Cybercrimes Amendment Act 2026, and provides that it is to be read and construed as one with the principal act and all amendments thereto. Clause 2, Mr. Speaker, modernizes the interpretation section by amending the definition of key to include or indicate that a key can be either electronic or digital. Go and learn that up. You should not be the leader of the opposition if you don't understand simple terms. Mr. Speaker, that is the key you need to know to unlock governance. Mr. Speaker, this definition, Mr. Speaker, is very important. It's a necessary update, Mr. Speaker, that given modern authentication, encryption, and digital access control realities, Mr. Speaker, we have to ensure that the terminology key is so defined that it encompasses today's realities. Clause 3, Mr. Speaker, amends Section 4 of the Principal Act. It strengthens protection for minors by amending, Mr. Speaker, the penalty framework of Section 4 of the Act, so that where an offense is committed, Mr. Speaker, through access to any computer program or data against any individual, Mr. Speaker, under the age of 18 years, the court, Mr. Speaker, may impose imprisonment for a term not exceeding 20 years. Clause 4, Mr. Speaker. It amends Section 8 of the Principal Act. It makes, Mr. Speaker, a corresponding amendment to Section 8. Likewise, Mr. Speaker, providing that where the offense, that is fraud or forgery, is committed against an individual under the age of 18 years, the penalty, Mr. Speaker, may include imprisonment for a term not exceeding 20 years. Clause 5, Mr. Speaker, amends Section 9 of the Principal Act to effect two significant changes, Mr. Speaker. First, Mr. Speaker, to replace the narrowing word "sent to another person" found in Section 9(1) of the Principal Act with the broader concept of published, Mr. Speaker. And secondly, to address a major modern harm vector, the non-consensual sharing of intimate content in the digital space, Mr. Speaker. Mr. Speaker, it creates the offense of publishing an intimate image without consent or being reckless as to whether consent has been given, Mr. Speaker. Mr. Speaker, it then defines the key terms in a way that reflects today's platform realities. Importantly, Mr. Speaker, the clause defines intimate image to include content that is captured, generated, or created, Mr. Speaker. And I repeat that. To include content that is captured, generated, or created. Mr. Speaker, this is very important as we are now living in an artificial intelligence age. Because, Mr. Speaker, the law must protect Jamaicans not only from what a camera records, but also from what modern tools can fabricate. Yes. Mr. Speaker, we have to ensure that those who seek to hide behind a computer or a similar device cannot cause harm, malicious or otherwise, to the reputations of Jamaicans. Yes, yes. Mr. Speaker, it defines published in a practical, technology-aware way to include sending, Mr. Speaker, transferring, Mr. Speaker, posting, Mr. Speaker, disseminating, Mr. Speaker, or otherwise, Mr. Speaker, provide access. You see, you don't learn, I know. But you will learn. You will learn. You will learn. Mr. Speaker, it makes it plain that a person under 18 is incapable of giving consent for these purposes, Mr. Speaker. And it provides, Mr. Speaker, carefully framed statutory defenses for legitimate publication context, including law enforcement, legal proceedings, bona fide educational or scientific and medical research, and reporting about historical or current events with reasonable care taken, Mr. Speaker, to omit explicit depiction. Where this offense is committed, Mr. Speaker, against an individual under 18 years, a term of imprisonment not exceeding 20 years may be imposed. Clause 6, which is the amendment of Section 10 of the Principal Act, strengthens Jamaica's ability to disrupt organized cybercrime by criminalizing without lawful justification the intentional manufacture, sale, importation, distribution, disclosure, or making available, Mr. Speaker, of a computer, any key, or any other data or device designed or adapted primarily for the purpose of committing offenses under Sections 3 to 9, and also criminalizes receiving or possessing such items with intent that they may use to commit those offenses. This clause goes directly to the modern reality. Cybercrime is industrialized. Tools are traded, rented, bundled, and delivered like a service. If we want fewer victims, we must also choke off the enabling infrastructure. Mr. Speaker, I also want to speak directly to the reality Jamaicans are facing with a sharp rise in fraud and scamming, particularly as it relates to banking and financial transactions. Too many citizens, Mr. Speaker, and businesses have had their accounts targeted through phishing and impersonation, payment diversion, account takeovers, SIM swap style tactics, and social engineering that now spreads at scale through messaging apps and social media. Increasingly, criminals are using AI-enabled tools, synthetic voices, manipulated images, and deepfakes to make these deceptions more believable and more dangerous. This bill, Mr. Speaker, strengthens our hands against that fraud ecosystem in a very practical way. It does not merely chase the individual scammer after the money is gone. It targets the enablers, the tools, the infrastructure, and the environments that make organized cyber fraud profitable. Mr. Speaker, Clause 6 is central to this. By tightening offenses around the unlawful availability, distribution, or possession of devices, data, and keys designed or adapted primarily for committing cybercrimes, Mr. Speaker. This is a very critical component as it relates to the amendment of this piece of legislation. Mr. Speaker, the law directly disrupts the pipeline of tools used to compromise accounts and facilitate illicit transfers. But plainly put, Mr. Speaker, we are raising the operational cost of scamming and increasing the likelihood of effective disruption, investigation, and prosecution. Clause 7, Mr. Speaker, amends Section 11 of the Principal Act. It updates language connected to nationally significant systems and services by inserting revenue alongside banking and financial services and updating the terminology medical system with health system. This is very strategic, Mr. Speaker. In a digital society, attacks on revenue systems and health systems are not only inconveniences. They are national disruptions, and they undermine public confidence by exposing personal data as well as economic stability. Clause 8, Mr. Speaker, repeal and replace Section 15 of the Principal Act. It creates, Mr. Speaker, a clear offense where the owner, occupier, or person responsible for the management of premises knowingly causes or knowingly permits the premises to be used for any purpose that constitutes an offense under the Act. With the liability and conviction, Mr. Speaker, of up to an indictment of up to 15 years imprisonment. This clause also reflects an important policy decision arising from the review process, Mr. Speaker. The previous compensation provision in the Cybercrimes Act is repealed, enabling victims to access the more comprehensive compensation framework under Section 24A of the Criminal Justice Administration Act. In other words, Mr. Speaker, we are tightening accountability for environments that knowingly enable cybercrime, while also, Mr. Speaker, improving the pathway for victims to be properly compensated. Clause 9, which amends Section 19 of the Principal Act, strengthens procedural discipline and accountability by requiring, Mr. Speaker, the Commissioner of Police to develop and implement a code of standard procedures to be complied with in any search and seizure under Section 18 of the Principal Act. Mr. Speaker, this ensures due observance of the safeguards contained in Section 19, which requires documentation of computer materials seized during an investigation. This is about effectiveness and integrity. Complex cybercrime matters often succeed, Mr. Speaker, or fail based on how digital evidence is handled. Section 10 amends Section 20 of the Principal Act. It makes, Mr. Speaker, consequential procedural updates, including aligning references in Section 20 to a warrant issued under Section 18 and updating the prosecutorial reference in Section 2. This, Mr. Speaker, is significant as a category of officers who can make an application for forfeiture of seized computer materials will no longer be limited to the Director of Public Prosecution, but now include clerks of the courts. Clause 11, Mr. Speaker, is a consequential amendment of the Interception of Communications Act. It aligns, Mr. Speaker, the Interception of Communications Act with the amendment referenced in Clause 2 by similarly updating the definition of key to indicate that a key can be either electronic or digital. Still not learning, but that is all right. That's all right, man. Ask Philip. Mr. Speaker, these amendments are not abstract, Mr. Speaker. They are citizen focused. They are meant for the young person whose image is weaponized. The family, Mr. Speaker, defrauded through impersonation. The small business targeted from abroad. And most importantly, Mr. Speaker, the Jamaican who wakes up to discover that their life has been digitally forged, posted, and distributed at scale. Mr. Speaker, I want to make it clear about the philosophy here. This bill is not anti-technology. It is pro-trust. Mr. Speaker, digital transformation only works when citizens believe the digital space is not a lawless space. The modern Jamaican economy cannot thrive if online becomes synonymous with unsafe. So today, Mr. Speaker, in opening the debate, I invite the widest, most practical debate across this honorable House. Let us test its clauses, Mr. Speaker. Let us pressure check its safeguards. Let us ensure it protects rights while enabling effective enforcement. But, Mr. Speaker, let us also move with urgency, because the threat landscape is moving with urgency. And the Jamaican people, Mr. Speaker, deserves a cybercrimes framework that is fit for the world they live in. Not yesterday, Mr. Speaker, but now. Not the world as it was when yesterday's technology sets the limits of yesterday's law. Mr. Speaker, I thank you.
Member from St. Mary's Southeastern.
Thank you very much, Mr. Speaker. I rise this afternoon as the opposition spokesperson with responsibility for digital transformation to make my contribution on the Cybercrimes Amendment Bill. At the outset, Mr. Speaker, let me state clearly that the opposition is broadly supportive of this legislation. We recognize the need to modernize Jamaica's cybercrime framework in an era where technology has advanced far beyond what was contemplated when the original act was passed, and where citizens, particularly children, seniors, and other vulnerable persons, face increasing risk online. I wish to commend the Joint Select Committee for the seriousness, balance, and diligence with which it conducted its statutory review of the Cybercrimes Act. That review was a critical step, Mr. Speaker, and it has brought us to the point where Parliament can now formally proceed to enact amended legislation that will meaningfully strengthen Jamaica's cybercrime detection, prevention, and enforcement capabilities. We also note that many of the committee's recommendations have already been adopted and agreed in the Senate, reflecting bipartisan recognition of the issues involved. Importantly, this bill does not impose any significant fiscal burden on the state. Mr. Speaker, there are several important measures in this bill that the opposition welcomes. First, the amendment and modernization of cyber-related offenses, particularly the amendment to Section 9 of the Principal Act to include the word publish. This is a significant and far-reaching improvement. Under the previous legislation, the focus was largely on sending information from one person to another. The inclusion of the concept of publishing now properly reflects the realities of the modern digital environment. It captures conduct involved sending, transferring, posting, disseminating, or otherwise providing access to images and data, including through social media platforms. Mr. Speaker, this change recognizes that harm today is often caused through public and mass dissemination, not merely private communication. It modernizes the act in a way that is fit for the new social media and digital era, and the opposition welcomes this amendment. Second, we support strengthened penalties for cyber offenses involving children, recognizing the seriousness of digital exploitation and predatory conduct. Thirdly, Mr. Speaker, we welcome the clearer treatment of harmful and malicious digital communications, ensuring that freedom of expression is balanced with the protection of dignity, safety, and reputation. I wish to place specific emphasis on social engineering, because in the Jamaican context, this is not an abstract cyber concept. It is fraud. The amendments now before this Honourable House rightfully incorporate the recommendations of the Joint Select Committee in this area. They recognize that social engineering has become a major driver of financial loss and emotional harm across Jamaican society, affecting individuals, families, businesses, and public institutions alike. By amending the original act to more clearly address phishing, spoofing, impersonation, and other deceptive practices, the legislation acknowledges realities of how fraud is now being carried out. These changes strengthen enforcement, broaden inclusion, and ensure that the law properly reflects the prevalence of these tactics within our financial system and other critical sectors. However, Mr. Speaker, there remains a significant enforcement challenge. Many of these fraudulent schemes and coordinated online abuses are carried out through fake or pseudo accounts operating outside of Jamaica's jurisdiction. For that reason, I wish to urge the government to give serious consideration to Jamaica's accession to the Budapest Convention on Cybercrime. This convention provides a proven framework for cross-border cooperation, mutual legal assistance, and the rapid exchange of digital evidence. Accession would strengthen Jamaica's ability to identify perpetrators and give serious exchange of economic action that is required to protect Jamaica's interests. Comparable jurisdictions, including the United Kingdom and Canada, already rely on these mechanisms. Looking ahead, Mr. Speaker, there's room for continued refinement. Other jurisdictions have recognized that cyber harm often involves patterns of behavior, coordinated fraud or sustained harassment, rather than isolated incidents. Jamaica must, in future amendments, move to further tighten how the law addresses cumulative and organized digital misconduct, as well as the role of platform cooperation in fraud investigations. It is important to acknowledge that the Cybercrimes Act of 2015, which this bill and the amendment proposes to amend, was itself a solid and forward-looking piece of legislation, which laid an important foundation for addressing emerging digital offenses and equipping law enforcement with the tools required at that time. The work of the Joint Select Committee, which has now brought us to this stage, is therefore commendable. Its careful and comprehensive review has ensured that the amendments before this Honourable House properly reflect the evolving nature of technology, online behaviour, and digital harm, and are responsive to the realities facing contemporary Jamaica. In closing, Mr. Speaker, what the Joint Select Committee also showed us is that our cybercrime laws are a composite of related legislation, many of which were referenced and recommended for updates and modernization. So, Mr. Minister, I'm urging that, as is noted in the report, that these legislation put forward for upgrade and amendments be placed squarely on the legislative agenda to strengthen our ability as a country to fight cybercrime going forward. I thank you.
Member from St. Andrew Southeastern.
Thank you, Mr. Speaker. I want to make two sets of comments. One, I want to start with process. The act that we are now seeking to amend is based on a Joint Select Committee that was established in January 2021. The Joint Select Committee substantively had meetings in 2023 and completed its work in May 2023. We are at January 2026. Now, when the amendment to the 2015 Act was done, we had built in a review after a 3-year period. The point I'm making that in 2026, we are now due another review. And the reality is that the work that would have been done almost 3 years ago would not have taken account of probably the most important development in technology over the last century, which is the advent of artificial intelligence. I make this point to say that the lack of timeliness of moving from a Joint Select Committee to a report to amendments affects this particular legislation more than others, because the nature of technology evolves so quickly. And so we have to ensure that, particularly for legislation of this nature, that we conduct the reviews and do the amendments in a timely fashion. There are two substantive points I want to make. First, the issue of reporting of cyber incidents. In the 2015 Act, we deliberately took the position that financial and other institutions there would be a voluntary obligation on their part to report. The experience and the evidence is that when you look at the number of reports in comparison to the anecdotal and the others that you know exist, the institutions are not reporting what is taking place. That has implications for policy. It has implications for a number of other things. And so a recommendation was made that we should move away from voluntary to an obligatory mandatory reporting to the regulator. And in this case, if it's a financial institution, it would either be the Bank of Jamaica or the Financial Services Commission. Now, obviously, no financial institution wants the publicity of acknowledging that there are breaches. But I'm sure if you speak to members here and in the general public, there are so many of us who have been victims of cyber criminal activity, particularly around banking transactions. And many of them are settled almost immediately. In a particular case for me, when I reported it, it was immediately settled. And I came to the conclusion that the bank acknowledged that it was a problem. I indicated I was not at that ATM at 1 o'clock in the morning, and I was refunded my money. But the reality is that these reports are not being captured by the regulator, and it is important that is so. The second substantive area relates to Section 9, which is malicious communication, which is the most controversial clause in this Act. In 2015, the Office of Director of Public Prosecutions published guidelines in relation to how the Act should be, this particular clause should be interpreted, read. And I just want to encourage the government in the public education to ensure that those guidelines are made available. They're in the public domain, but to reinforce, because we are in an era where people believe that once you're online, you can't say and do anything. And because it is difficult for the people who are offended to pursue the matters, people feel they have a license to almost act outside the law. So I want to encourage the dissemination and the inclusion of that report by the DPP's office surrounding Section 9 in all public education going forward on a continuous basis, so that the public is aware that the persons who are prosecuting, both law enforcement and prosecution, and the judges too, can be up to date with how that report dealt with Section 9. I was a member of the committee that did the review, and as my colleague from Southeast St. Mary said, we are broadly in support of the recommendations that are made. But the main point I would like to make is that with the passage of time, we are almost due now another review of this Act to ensure that we incorporate the new advancements in technology, particularly around artificial intelligence. Thank you.
Member from Portland Eastern.
Thank you, Mr. Speaker. Minister, I rise to support the amendments to the Cybercrimes Act. I just wish to make a comment on Clause 8, which would be Section 15. And just to point to you what I genuinely believe may bring some fear or apprehension or fear of prosecution in relation to the lack of a definition in relation to the premises that is intended to be covered in this section. So it's not a criticism, it's just a wonder, and in light of what my friend from St. Andrew, Southeast would have said, whether or not it's something that could be reviewed. Nothing I say here I think would prevent the passing of your legislation, but just wondering if it's something that we need to look at. In certainly the Dangerous Drug Act, the fraudulent transaction legislation,
a lot of the activities are physical. This section, as worded, speaks to two types of knowledge. Actual knowledge, which is the knowingly cause, and then there is the turning a blind eye, kind of strict liability, being negligent. What is a little bit problematic is whether or not how we define who is the person in control of a premises, and whether we can control, as the section speaks about, any act under the Cybercrimes Act. You as a premises owner, landlord, I can go to even the warder, to the minister of the state minister in security, even the warders in the prison institutions, and cell phone access, especially with the malicious communication, whether the premises and how liability comes about by a failure of defining the premises in relation to cybercrimes, because it's not general, or we can't make it comparative to the Dangerous Drug Act, where there's some physical substance that somebody can, or activities in and out of a premises. Youth club persons, community centers can find themselves in trouble with the law because the definition is not restricting or kind of giving guidance out of the legislation by the definition section. So I'm just raising it to say it may be something to consider or review. It won't prevent, I support it 100%, but there was a famous case, Sweet and Parsley, where Lord Reed would have said we're not in the business of turning ordinary citizens into criminals. And a section like this also gives police wide powers to enter premises that has sometimes a owner, landlord, sublease, a lessee, or even family members who would not have known in a situation where TikTokers or teenagers decide to send malicious communication, or is in problem with multiple girlfriends and decide the TikTok drama that unfolds, and you find parents in trouble, or pastors in churches, youth clubs. Just something to consider. Thank you.
Member from St. Andrew Southwestern.
Thank you, Mr. Speaker. I rise to add my few words on the report of the Joint Select Committee to the Houses of Parliament on the Cybercrime Act. I want to say that there is really nothing controversial that I have to say, hopefully, today. That, as others have said, I agree with the direction of the amendments that are made. There is just one little provision that I am opposed to, and I'll tell you why. I listen to that. I know that the recommendations include repeal of Section 15 and provides for compensation of victims of cybercrimes and all of that. As I looked at it, though, I was thinking that in as much as we talk about three main incidents that occur in terms of cybercrime as being abusive content, impersonation, and revenge porn, for me, one that we have not paid sufficient attention to is reputation sabotage. Right? And that is as well a big one, and it has been a big one in Jamaica. We look and note that in the first 6 months of 2025, we saw 34 million cyber attack attempts. Huge, yeah? And so all of the various categories, I think, are important for us to look at. And I didn't note enough attention being paid to that. I raise that, Mr. Speaker, because I'm sure you would not be surprised to hear that there are members here and many Jamaicans who every day will come and laud, big up their social media individuals. And when you go and check, you will actually see that some of those same persons are and this is not the first time I'm saying it in the House, yeah? And I do say it because I have been the subject of it. So for me, it is personal and it is offensive that there are individuals associated with colleagues who could be spreading information that they should know is false and that is really meant to cause reputational sabotage and damage. And so for me, that is a big one that I think we need to look at. And I feel very strongly about that. In terms of the one issue that I am concerned about, to you, Mr. Speaker, is is included in Section 9 of the Principal Act and is on page 3, that is 5(1)(c), D, and E, where it says that it shall be a defense in any proceedings for the commission of an offense under Section 1A for the defendants to show that the image that was published, yes, was for bona fide educational, scientific, medical, or research purposes, or for purpose of reporting about historical events. And the only question that I'm asking is, if it is something that is offensive to me, is this saying that these are good grounds for it to be republished or reshared under those circumstances? And is it expected to be done without my consent or without saying anything to me? I'm very uncomfortable about that. And so I want to ask that as a question. The rest that I wanted to say, Mr. Speaker, is not about what is in the bill, but rather what I thought needed to have been addressed, notwithstanding the focus of the Joint Select Committee. As the member from Southeast St. Andrew has said, with the lapse of time, I know that there is, and it should be shortly, an opportunity to revisit the bill and to address some of these issues. And so the first one is really about inadequate penalties, because you would know that there are a number of individuals who believe that the penalties for offenses, that they are not sufficient deterrent for unauthorized access to computer systems. Currently, it's what, $2 million and up to 2 years, when we have similar jurisdictions to ours that have 5 to 10 years. And so I think that that is something for similar offenses that we should be looking at. And then is the limited scope, yes, of the bill, because it does not fully address, and I think the member mentioned that as well, emerging trends and technologies, yeah, and in particular the issue of spam. Also, the difficulty in prosecution, as many have actually noted, yes, and you will know that the investigative capacity, yes, is not there to give the kind of support that the bill needs for proper prosecution, for wider prosecution, yes? And so I believe we also need to look at the investigative capacity of law enforcement agencies for that. I also saw, I think it might have been pretty close to the time that the Joint Select Committee might have been meeting, a discussion by the Office of the DPP around broadening the Cybercrimes Act to empower clerks of the court to actually seize computers that are engaged in these kinds of activities. And I thought that that was worthy of being considered, and so I wanted to recommend that. And then, as I end, Mr. Speaker, through you to the Minister, I believe that any revisit of the bill should really ensure that it focuses broadly on protecting human rights, and that it doesn't have a narrow focus on the misuse of computer networks and dissemination of objectionable information. I think that where we are in the world and what's happening in cybercrime, it needs to be more broadly focused. And then finally, I want to add my own words to the member from St. Mary who spoke about accession to the Budapest Convention. The truth is that Jamaica as a jurisdiction, we have partnered with the Budapest Convention, with Pegasus and a number of other initiatives, but yet we have refused to accede to the bill. The truth is, and sometimes to the convention, the Budapest Convention. The truth is that often I hear our leaders saying that this is a convention that is more in tune and meant for bigger countries, more developed countries, and for Europe, etc. The truth, though, is that there are other Commonwealth countries that have acceded to the convention, yes? Even right here in the Caribbean. And as I said earlier, Jamaica has partnered with the Budapest Convention on projects like Pegasus and all of that, and they have noted immense benefit, yes, from the international collaboration and from the technical support that we have received under the Budapest Convention. So I want to place those on record, Mr. Speaker, as in terms of my opinion and my hope in terms of what I'd like to see in the future around a cybercrimes bill.
Member from St. Andrews Southern.
Thank you, Mr. Speaker. Yes, thank you. Mr. Speaker, I rise to make a few brief comments on this bill that's before the House. The broad point that I wish to make is really consistent with what has been said here by the member for St. Andrews South East. I must say that for me, for a bill dealing with cybercrimes to be brought to the House in 2026, which is addressing the contents of a Joint Select Committee report written in the first half of 2023, and which does not fulsomely address the very serious issues which have arisen with the advent and pervasiveness of artificial intelligence, is a great disappointment. This bill ought to be doing that, because we are living in that age now, and the issues that it presents for our society are real. The law needs to more fulsomely protect persons' images, the image of an individual, their reputation, and the use of their appearance and their voice and other biological manifestations through manipulation to denigrate them, to spread falsehoods, either about them or others, or things that they have alleged to say which are complete fabrications. These are very serious problems. And I think for the bill to come here and not address that is a disappointment. We cannot say that we are protecting our society and keeping on the cusp of technology when we are not. We support these amendments, but they're dated. they are not dealing with the most pressing problem that has arisen in the last 2-3 years. And I hope, Minister, that you will give a commitment, although I see the bill is not tabled in your name, but I hope you will give a commitment that the government will move rapidly to convene another Joint Select Committee to update this legislation to address the pressing issues which have emerged in the last 2 or 3 years because of the advent and the growing power and influence of artificial intelligence, which jeopardizes the society while representing a tremendous opportunity as well, but there are clear and present risks and dangers that come with it that we need to protect the society from, and this bill does not do that. There are 2 other points I want to make. When the minister was giving his opening, he made reference to the fact that there are actually 2 amendments in this bill that make the same point, Clause 2 and Clause 11, which insert after the words any key or key, the words whether electronic or digital. And I asked, hoping that he would explain, what is the difference between electronic and digital, those 2 concepts here? And his response was less than accommodating and unnecessarily so. Yes, especially coming from a minister. I mean, clearly, if he's not sure of it, if he's not sure of what the difference is, there's a technical team here to provide that type of guidance. And I hope we will get it. I'm hoping that we will get that guidance because the question is a legitimate question and I would like to understand the difference. Yeah. The other point that I wish to make relates to Clause 5 of the bill, which is dealing with Section 9.
Members. The members on the members. The person is on. The member is on his feet.
Thank you. Thank you. The other issue I wanted to raise has been mentioned by the member for St. Andrew Southwest, and it relates to the defense that is set out in Clause 1C, big C, to the new offense which is inserted by Clause 9(1)(a). And it relates to the publishing of intimate images. And 1C speaks to defenses to that offense of publishing intimate images about somebody without their consent. And one of the defenses talks to or speaks to publishing for the purpose of reporting about historical events. Now, I want to know what that means. What are historical events for in this context? Is a historical event something which you find in a history book? Or is a historical event something which has occurred in the past? And maybe the recent past. It may be last week. So from that perspective, given that this is a defense that will remove the protection to the individual who has had intimate images about them published, it ought to be very clear what that defense is trying to address and what it is not trying to address. And as presently formulated, it is too general, it's too abstract, and it, to my mind, could undermine the intent of the new offense, which is to protect people from violations of their privacy through the publication of intimate images. So, Mr. Speaker, I hope that those two issues will be addressed, and I also hope that the minister will assure the House as to when a joint select committee will be convened to modernize this legislation, to take into account the new age that we're living in and the risks and dangers that we are all living through on a daily basis in the absence of legislation that adequately addresses those risks and dangers. Thank you, Mr. Speaker.
Member from St. Catherine Southeastern. Call it. St. Elizabeth Northeastern, sorry.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make my contribution in respect of the Cybercrimes bill. Like most members of the House, I do generally support the amendments being brought before the House in a general sense. However, as indicated, there are concerns, Mr. Speaker, as it relates to the artificial intelligence component. And I rise because, as the minister would have indicated, quite a number of times during his statement, quite a few references were made to AI, but when I had sight of the proposed amendment to Section 9, which is the offense-creating section of the Act, I noted, Mr. Speaker, that there was actually not sufficient ground in this section to mount a prosecution for persons who would have utilized AI to, one, forge documents, and that is very important considering where we are today in our society, and two, even as it relates to the creation of intimate images, which is specified here in Section 5, regrettably, I fear, Mr. Speaker, that the section does not sufficiently address the use of deep fakes, which is really getting to be so rampant in today's society. And so I wonder, without there being the need for too much delay, whether the minister might be minded to have the relevant team redraft this particular section so as to make it possible to mount a successful prosecution, to address the use of AI to forge documents as well as to manipulate video. Let me be clear, as a practitioner in the legal system, when I look at this section, I can see where a defendant can very easily say, having used AI to create a deep fake image of an individual, of a real person, can realistically say before a court of law, but this is not an intimate image of any individual, because this is not a real person. And so it is a real risk that we all face. It is a real risk. It is a real risk that we all face in this House. And so I do not rise to be partisan. I rise to see how best we can have a meeting of the minds so as to protect the Jamaican public in this respect. And secondly, I note at 1C, subsection 1C, that it is a defense in any proceedings for the commission of an offense under the very same subsection that I referred to just now, for the defendant to show that the image was published only to the individual depicted in the image. And this causes great concern for me, Mr. Speaker. It raises great concern because I wonder, is there a reason why there should be a defense simply because the image was disseminated only to the person, the affected person? Why should it be a defense in circumstances where one of the most critical developments that we've seen now are instances where persons suffer such mental distress, mental anguish after having seen their images plastered or perhaps even not shared but simply sent to them? It causes such anxiety. Why should it be a defense simply because the image was simply shared to the person in question, to the victim? Why is there need for there to be a defense in this respect? This is a matter that a judge can properly bear into consideration in determining matters to do with sentencing. It's a mitigating factor, if you will, at the very highest. But I really am unclear, Minister, as to why it is included as a defense. And if it is a defense, is it an absolute defense or is it a qualified defense? This section does not make it clear. And so my question to you, Mr. Speaker, is there a reason for the inclusion of this particular section which provides that if an offender simply publishes the image to the victim, then that's a defense? Why is it a defense? Why is it a defense when mental anguish can be caused by publication to just the victim? Why is it a defense? And finally, in an age, Mr. Speaker, where we understand that one of the most difficult challenges faced with cybercrime legislation is that to deal with enforcement. Enforcement in the sense that many cybercrimes are actually committed by persons residing in other jurisdictions. And so against that background, there is a need for strong international collaboration. I therefore rise to ask in tandem with the learned members, is there a reason, is there a policy reason why we have not acceded to the Budapest Convention, which would actually allow for extradition of persons in other jurisdictions that commit cybercrimes offense, as long as you are a member or a party state to that convention? And so those, in short, Mr. Speaker, represent my contribution.
Central and Southeastern.
Thank you, Mr. Speaker. Just two quick comments, questions, Minister. And I think the bill is timely, and I wonder, though, first, the focus on generated images does not make any provision for audio, and we know that deepfake can also cover and be used to have what are called voice cloning and so forth. So that more explicit use of, or at least broaden what is generated from images only to also include audio is one consideration which I'm asking that we make. Secondly, the generated images focus on nudity with good reason. And it is important, however, that we also think about the other ways in which generated images can cause harm, can cause anguish of one kind or another, as the member from Northeast St. Elizabeth said. And so to broaden what we're speaking to so that we do not have to come back here in short order to revise the bill would be important. My second point has to do with reporting. We know from the Child Care and Protection Act that there is mandatory reporting, so that is covered in another act for children. And from my understanding of this bill, reporting as well where we know of a premises where activity is taking place. And I'm asking for consideration, Mr. Speaker, of reporting, required mandatory reporting, whenever it is known that someone is involved in generating or participating in activities that would be activities that would be criminal under this bill, so cybercrime activities. Because at the moment, we can know and close our eyes to it, but if the law requires us to report as it is required for children, I think it would help us to take a step further to ensure we're protecting children, and especially the elderly, who are often victims in this regard. Thank you.
Member from St. Catherine Southeastern.
Thank you, Mr. Speaker. Mr. Minister, so there are two things. One, I think we can all agree that we have to remove nudity or intimate image from the bill. The other thing I want to speak to, and this is from a personal note, because every day my office is bombarded by people who want to know about the blood pressure medication I spoke about in the video. And what is happening is that there have been AI videos generated of myself educating people about blood pressure, prostate, and all of that. And it is simply not true. So, and even my own colleagues here are calling me about their constituents, and I have to put out press releases. So I am a victim of this heinous act. So I want to draw your attention to Section D, where it says for bona fide educational, scientific, medical, or research purposes, that has to go, because what they're doing is using my image to educate people on these conditions and then lead them to a website. Well, it's a bona fide educational video because some of what is said is true. But it is using my image without my consent, using, so fraudulent. So, no, but it's the idea that they're using my image to educate and then to lead someone to a clickbait site. So it may need to be reviewed, Minister, to protect people like myself who educate legitimately.
You can't be so defensive, man.
Minister.
Thank you very much. We're not closing, we're not closing, we're closing next week. We're still in public business, right? Okay, thank you. Wonderful move to table that bill, long in coming. As was stated by the House Leader earlier in relation to the criminal justice, child diversion in the criminal justice system, I wish to continue and move for the... Sorry. Andrew.
Let me tell him.
Mr. Speaker, I move for suspension of the debate until next week, Tuesday. Until next Tuesday.
The request is on the floor for the suspension of this bill. Those in favor? Those against? The debate, sorry. Those in favor? Those against, the ayes have it. House Leader.
Thank you very much. As it relates, the Leader of Government Business would have already, at notices of motions given orally, started this process, so I want to complete it in his absence. I now move for the suspension of the standing orders to enable me to take the motion, notice of which was given earlier by the Leader of Government Business.
Those in favor? Those against, the ayes have it.
Mr. Speaker, I now move that the motion, notice of which I gave earlier, be approved.
Those in favor? Those against, the ayes have it.
Mr. Speaker, I am happy to announce that the Minister with responsibility for culture is in the House, and she would have wanted to give her statement earlier, but she had state duty. So I'm asking that you recommit to statement by... You want to? Oh, but before that, in public business, the Minister of Justice wants to suspend a bill.
Mr. Speaker, colleagues, I propose to close the bill and go to committee stage with the Jury Act, but some slight further amendments need to be made, so I'm asking for further suspension to next week.
Those in favor? Those against? Ayes have it.
Thank you, Mr. Speaker. I now ask that the House approve a recommittal of statement by ministers to allow the minister to make her presentation.
The request is for the recommittal to...
No, I'm sorry. I humbly apologize, Madam, to allow the acting Prime Minister to make her presentation.
Those in favor? Those against? The ayes have it. Statement by Minister.
Thank you, Mr. Speaker. Thank you, House Leader. Mr. Speaker and colleagues, it is no coincidence that Reggae Month is observed in February. I do. The House does not recognize an acting PM sitting in the Prime Minister's seat. No, it's Mr. Speaker, I ask for permission to speak from a seat.
Permission granted.
Thank you, Mr. Speaker. And it's my pleasure to make this statement today on behalf of all my colleagues in Parliament. It is no coincidence that Reggae Month is observed in February, as it coincides with the birthdays of two of Jamaica's most influential cultural icons, Dennis Brown, born on February 1, and the Honorable Robert Nesta Marley, born on February 6. Their lives and legacies reflect the depth, the reach, and enduring power of reggae music. So February, therefore, provides a fitting period for national reflection and celebration, anchored in the contributions of artists whose work continues to resonate across generations and borders. Reggae Month 2026 reflects both tradition and renewal. More than 60 events have already been registered with the Reggae Month Secretariat, including activities organized by the Ministry and the Jamaica Cultural Development Commission, initiatives led by the Jamaica Reggae Industry Association, JERIA, and endorsed events staged by private promoters across the island. Mr. Speaker, rather than viewing Reggae Month as a simple list of events. It is more accurately understood as a cultural journey, one that honors our pioneers, celebrates contemporary creativity, and deliberately nurtures the next generation. We are especially encouraged this year by the strength of partnership within the music fraternity itself. Promoters, producers, artists, and industry stakeholders are playing an increasingly active role in shaping the celebrations. Initiatives such as Dance All Week demonstrates how the culture continues to evolve while remaining firmly connected to its roots. And this year, Dance All Week will be co-hosted by Ramesh, who is one of our most outstanding promoters. These partnerships ensure that Reggae Month remains dynamic, inclusive, and relevant to diverse audiences across age groups and communities. As is customary, Reggae Month begins with praise and thanksgiving on February 1. Praise and worship. And this year, the Reggae Month church service will be held at the Fellowship Tabernacle on Fairfield Avenue, providing an opportunity for reflection and gratitude as we commit the celebrations to God and acknowledge the spiritual foundation that has always underpinned reggae music. Many of our artists came out of the church. And we thought Fellowship Tabernacle would be the most appropriate church because Reverend Al Miller, we call him the reggae pastor. Also on February 1, we will honor the late Crown Prince of Reggae, Dennis Emmanuel Brown, with a tribute at National Heroes Park. This observance recognizes not only his immense contribution to Jamaican music, but also his lasting influence on generations of artists and fans at home and abroad. Minister Mackenzie, the MP for West Kingston, and myself had the honor of coming from the community, the same community as Dennis Brown. And we had pleasure at the time to refer to him as Little Dennis Brown. And we're, a little older than him. We'll take him with us. We'll make sure we take care of him and all of that. And, for us, it was really an honor to have known him and to have associated with him. We will then pay our respects to the King at the Bob Marley tribute concert at Emancipation Park on February 6th. This year's tribute will bring together overseas acts, including a group called Out of Control Army and another group called Sangre Maize from Mexico, alongside, of course, our local talent. And we will be co-hosting this event along with the Bob Marley and Rita Marley Foundation. The two bands, the two groups from overseas who are participating serve as a powerful reminder that while reggae has traveled the world and inspired international audiences, its soul and source remain firmly rooted in Jamaica. So we welcome peoples of the world who enjoy our music and who participate. When you go to Rotterdam Sunsplash, you find people of all nations, thousands, with dreadlocks to their ankle. And they preach and live the life of Rastafari. And we should be so proud that as a little country, we have been able to give the world a new religion in Rastafari, a musical icon in Bob Marley, and so many other wonderful things about our culture. And so we look forward to the Bob Marley tribute, and I'm hoping that I will see all of you there, because it's quite an experience. Reggae Month also places deliberate emphasis on the future of the music. The next generation will be given their moment in the spotlight through young reggae gospel ambassadors in Negril on February 8. We are affirming our commitment to nurturing emerging voices and ensuring the continued growth and relevance of the genre. So during Reggae Month, we promote emerging artists. We refer to them as young reggae ambassadors, or we refer to them as children of the icons, because a number of our reggae artists, their children are following in their footsteps. And we use Reggae Month as an opportunity to give them the exposure and to nurture them and encourage them to continue to build our music. Western Jamaica will once again have their share of Reggae Month energy, with activities including the Mobe Reggae Night on February 22, reflecting the island nature of the celebrations. And in highlighting specific activities, I also want to indicate that in every parish and almost every community, you have promoters who are planning Reggae Month events. And we have asked the police to give support to these activities, allow them to have their events, give them their permits, and I will sign the extension for these activities to be held. So the ministry will host 2 symposia on February 11 and 17. And one is examining the entertainment registry, which we refer to as the e-registry. And the e-registry is a very important database that we use to recognize persons in the industry and to offer them incentives. And, you know, I share the success of the e-registry with Member of Parliament Damien on that side, who was a part of developing that program. So we offer assistance to the industry, but you must be a member of the e-registry. So what it does, it gives us the data we need for the industry, and it allows persons in the industry to be able to bring in their tools of trade tax-free. They are part of the entertainment industry insurance plan. They get tour support and a number of other support from the ministry because they're part of the e-registry. So the symposium, the one on the 11th, will examine all the benefits if you become a member of the e-registry. And we will also use it, that symposium, to teach you about estate planning, because a lot of artists, they pass, and then there's a big issue within the family, who benefits. Within the family, there is a lot of confusion. They didn't make any plan. They did not name someone who would, a beneficiary on even the health insurance. We are insisting now that they do so. And so we want to ensure that in whatever we do, we make sure that the industry and participants are more organized and structured and benefit. And then we will also have on the 17th the celebration of 60 years of rocksteady music. Because we have given the world many genres of music: ska, rocksteady, dub, and as we continue the journey, we recognize the milestones and we plan events, the appropriate events. So this year, we will be celebrating 60 years of rocksteady music. Now, the sound system culture is not being left out of the Reggae Month celebrations. This year, we host 8 sound systems in a one big lawn. And I must tell you that My great-grandmother lived in a dancehall setting, Chacmo Lawn, where a lot of the pioneer artists and musicians were part of that Chacmo Lawn experience. And so the dancehall is important because it's a base of our music. So we will have
Mr. Speaker, the member's time for speaking has expired. We ask that it be extended by 10 minutes for her to complete her presentation.
The request is on the floor. Those in favor? Those against? The ayes have it, Madam.
So at Mass Camp, we will have 8 sound systems in a one big lawn on February the 15th. Now, 10 years ago, Kingston was designated a creative city of music by UNESCO. And we will celebrate that milestone with what we call Kingston Rhythms on February on February the 22nd. The weekly live music jam session, Tuesday service, we call it Tuesday service. I'm sure some of you, you're not aware of Tuesday service. I'm inviting you to attend every Tuesday service. Celebrates its 2nd anniversary and is back on the Reggae Month lineup on February 24. The Island Music Conference, hosted by Shaggy, is now in its 3rd year and again promises to educate and inform industry players by bringing in some of the leading voices in the entertainment business overseas to share insights here from February 25 to 28. In addition, Dancehall Week will run from February 22 to March 1, highlighting the vital role that dancehall continues to play in Jamaica's musical evolution and its connection to reggae's broader cultural journey. The Reggae Gold Awards will take place on 27, recognizing excellence across the reggae industry. And this year, Mr. Speaker, we pay special tribute to Jamaican music stalwart singer Ken Booth, with the entertainment package including performances by a number of our outstanding artists singing Ken Booth hit songs. Now, Ken Booth, you know, he's not in the greatest of health at this time, but his voice is still fantastic. And we will have him there, and he will enjoy just having his colleagues performing his hits. And if he feels like it, he will go on stage and perform as well. There's a saying, don't send me flowers when I'm gone. And so we're making sure that we honor him on this occasion. And the highlight also of Reggae Gold is Luciano being special guest artist accompanied by the Reggae Symphony Orchestra. We're also seeing clear evidence of reggae's global reach and continued relevance. All nominees for this year's Grammy Award for Best Reggae Album are Jamaicans. And that is something we should celebrate. Because there was a time where we felt they were taking our music from us. But we can be really very proud that all the nominees for this year's Grammy Award for Best Reggae Album are Jamaicans. That achievement reflects the authenticity, the leadership, and creative excellence of Jamaican artists and producers in a highly competitive global industry. It reinforces the reality that while reggae is enjoyed worldwide, its creative center, its nerve, remains firmly anchored here in Jamaica. As we observe Reggae Month 2026, we're also strengthening access and engagement through digital platforms. The Reggae Jamaica app provides real-time information on events and activities throughout the month, making it easier for Jamaicans at home and abroad to stay connected. Members of the diaspora are encouraged to participate virtually, culturally, and where possible in person as part of this national celebration. And I should indicate here that the Minister of Tourism and Culture from Sierra Leone will arrive in Jamaica tomorrow for Reggae Month. This year also marks an important new step in the evolution of Reggae Month. For the first time, the Ministry of Culture, Gender, Entertainment and Sport, through the JCDC, has appointed a Reggae Month ambassador. And this initiative strengthens advocacy for reggae locally and internationally and highlights artists who embody the values, the integrity, and cultural responsibility associated with the music. So I am pleased to note that reggae singer Etana has been named the first Reggae Month ambassador. And so she'll be bringing her voice, her experience, and her international reach to this role. So in closing, Reggae Month represents Jamaica's cultural responsibility to honor, protect, and promote one of our greatest contributions to the world. At a time when our nation has experienced loss, recovery, and reflection, reggae continues to remind us of our resilience, our creativity, and our shared identity. All our artists came on board after Hurricane Melissa, and they did a tremendous job. They were like part of the first responders. They hit the ground, and they were out there assisting our people. And the response has been tremendous in the Isle of Jamaica series of shows. Maybe next week I'll come to Parliament to announce the funds that we have raised so far. But we have done very well, and all our artists have really shown how much they love Jamaica. Unfortunately, we are losing our pioneers. And, you know, today, for example, is a very sad day because we lost Cat Core, and then we lost Sly Dunbar. Never Garrick, who was Bob Marley's art director, who passed. I think it could have been last year. We lost his wife this morning. We lost Bob Clark, who worked very closely with me when we established IRI FM. And, you know, the passing of our pioneers and those who have paved the way will create a void that is going to be hard to fill. Next week, we will pay tribute to a number of these artists. We won't be doing it today. We want to invite Cat Core's family and Sly Dunbar's family to Parliament next week, and Bob Clark's family. And so delaying our tribute for next week, we'll have them present here so that they can share in the tribute. So while the world enjoy reggae, and while we mourn the loss of our pioneers, reggae music remains the soul of our culture. Thank you so much.
Member from St. Catherine, Northwestern.
Mr. Speaker, I want to thank you. I want to thank the minister and her team, including the junior minister, for presenting the Minister of State. I stand corrected. I stand corrected. I stand corrected. But I'll leave it to Wame to start you out with it. But, Mr. Speaker, I want to congratulate the team for presenting a plan that seems to be fitting for Reggae Month and for a genre that has contributed so much to the Jamaican space, the Jamaican identity, and the Jamaican reality. Mr. Speaker, only an individual who loves the music in this way could have been so fulsome in her representation of what Reggae Month should include and feature going through the period that exists. However, Mr. Speaker, I still believe that we are leaving a lot on the table for what reggae, dancehall, and the Jamaica's entertainment as an industry can do for our nation. As was highlighted, many of our stalwarts are now being lost to the natural circumstances of biology. And to that extent, we should move hastily to capture some of their stories and information in documentaries, etc., so that that can be shared with our children moving forward. I have often wondered, in a time that even the pigment of your skin was resisted, how did Rastafarians endure touring in Europe and the United States in the 50s and 60s? We would love to hear those stories so that history don't repeat itself. We also feel it is time for us to have our own entertainment walk of fame. I think that these persons should be honored in their time, and a walk of fame would be able to capture many of these individuals who have contributed greatly. In our time, we are, well, you don't have to steal it, I'm giving it this time. Well, in our time, we had looked at the park in New Kingston as one of the areas that were, not, you are my friend, you know, he, not so much. All right, I take it, you are my friend. But we were looking at the park in New Kingston as a possible host for such a walk of fame, and the NHD, who has duty to the park, could always contribute to such a maintenance of a entertainment walk of fame. I am pleased with the continuation of the entertainment registry and its development. However, yes. And also, Kingston as a creative city, 2015 December. However, there is also opportunity to expand on that. I however feel, Minister, that there should also be an extension of the celebration of the culture at a constituency level. I believe that constituencies should have been offered the opportunity to suggest programs and to have plans so that they too could celebrate the reggae industry, not too late, on a localized level that also creates ownership of the industry. It is, and yes, there's an example of how well you did something for independence and that celebration that could have spanned the entire, and the TEF could always be called on to participate in that, because many of us here, our constituencies, have limited access to some of the events that has been highlighted in the centers of the nation and would not have had.
With the Members' time for speaking having expired, we ask that he be given an extension of 5 minutes to complete his presentation.
Those in favor? Those against, ayes have it. You may continue. Mike.
Thank you, Mr. Speaker. Additionally, yes, Mr. Speaker, we'd hope for a consideration of an expansion of impacts to the constituencies so that there could be ownership of such a global industry within the space. Also, Mr. Speaker, we ask for the revival of the entertainment ambassador program, because they have been chief influencers to traveling to Jamaica, chief influencers to consuming the tourism product. And there is an opportunity to partner with these individuals as ambassadors. We believe also it is fitting for us once again, Minister, to recognize how important dance is to the entertainment industry and to the reggae industry as a whole. And also we have seen where there has been the utilization of our creativity without much compensation to those who were the original creators. No less of than a Beyonce used dirty wine. I don't know if I can say that in Parliament. Dirty wine. Dirty. At the NFL stage, with not dirty wine, with not even a mention of those who were the chief creators of that activity. Finally, Minister, the extension of entertainment activities cannot be reserved only to the February period. As you know, is a space for which many have depended for economic existence and survival. All the round robins, etc. And it is an area of real concern to me because of the prejudice that I've seen. Large events have never been subject to the Noise Abatement Act. Never have I seen noise abatement for Sumfest. Never have I seen noise abatement for Sting. Never have I seen noise abatement for large activities. But at any given time, the police can always encounter those who are trying to start with the Noise Abatement Act. There must be a legitimate method for application and implementation of extensions. I congratulate you on starting the event zones, and we see one there out in Fort Rocky. I hope to have conversations with you about extending to community zones, and again, calling upon our colleagues to make recommendation of what could be an extension zone within their own communities for evaluation from the police and others to ensure that the nuisance of entertainment don't disturb those who don't want to participate. Once again, Minister, I'm pleased of the effort that I've seen put forward here. I'm pleased of the fulsome activities that gives reggae a celebration that it deserves. And I really hope we can work together as a nation and as a parliament to take the full value of what entertainment can bring to our people and our country. Thank you very much.
Member from St. Mary Central.
Thank you, Mr. Speaker. Before asking the question, Minister, you can count on my support. And I think some very good amendments have been made to the suggestions have been made to the lineup for Reggae Month. I'm very happy that dancehall is being given some pride of place in terms of the celebration, and you managed two of the entertainers who were kind of the soundtrack to my life growing up. Don't know if I'm allowed to name them, but you can count on the support in that regard. Dancehall Week, Madam Speaker, this is something that has been close to me for some time, and I'm happy to hear that someone with the talent and resources of a Ramesh has been added. I just want to know whether the conceptualizers and the original organizers of Dancehall Week who struggled with the product, whether they will continue to be a part of it. Dave Golson comes to mind, for example, as one of the persons. In terms of the localizing of the celebration and making it relevant to constituencies and parishes, I sat down and before the member who responded spoke, I was trying to identify a parish like St. Mary in the celebration, which has provided entertainers such as Panhead and Capleton and Yaxter and a whole Berry Salmon, a significant number. And so I want to know, Madam Speaker, the local promoters who you have indicated that you're listing, I want to know the nature of the engagement, whether we're just documenting or we'll be providing any support, and if there's a mechanism for local promoters who want to participate in Reggae Month to submit and be able to participate. Is there an official, I know you mentioned some elements of the calendar. Will you have signature parish events, for example, that we can look at and see how we become a part of it? In terms of the symposium, I want to know if these will all be in Kingston and the West or whether they will be extended to outer parishes, because in the outer parishes we have a lot of people who make a living from entertainment but might not be the mainstream names and faces that you would know, and they could benefit from the information. So whether it is to digitize and share or it is to have some smaller symposium in other parishes. And that is it. You spoke to the fallen pioneers, and next week you will do a tribute, and we'll be on that. Thank you.
Minister.
Thank you. Thank you, Mr. Speaker. I want to thank my two parliamentary colleagues for their contribution, and I've noted your recommendations and suggestions. I just want to highlight the fact that during the course of Reggae Month, at some point, I will be making an announcement about the next steps to the development of the Jamaica Music Museum, of which Herbie Miller is the curator. We're in final stages of a discussion with a major record company, the largest reggae record company in the world, to collaborate with us in developing the Jamaica Music Museum. We broke ground, and we are now moving to the stage where we know we can fund the development of this museum. Yes, the idea of a walk of fame, that is also going to be pursued, but the Reggae Gold Awards is an occasion when we induct our performers into the Hall of Fame. And so that event will be held, and there are some recommendations that have come in, and they are being looked at. Now, yes, during the independence celebrations, I was able to negotiate funds that you were able, or MPs were able to do something extra during the celebrations. Because of Hurricane Melissa, I've not been able to negotiate those funds for Reggae Month. But you have your Constituency Development Fund, and you do have some... I'm not a magician, you know, right? But I'd still ask. But you can, I'm sure you have some allocation for cultural activities that you may want to put on some community dances, right? But there are promoters in every parish who are putting on events. I mean, I can make available to you a list, and you may want to reach out to them and find a way to identify and to be a part of that. There are a few promoters who have written to us to ask us for sponsorship, and we are considering. So it may not be a lot, but we will be giving support to some promoters. Now, there was mention about dance. Dance is important with the music, and we have had many outstanding dancers who have come up. And Mr. Seaga would say, the late Edward Seaga would say, in Jamaica, there is a move to every music, right? That's why you had the ska, then you had the ska movements. And so we have been able to create a dance for every genre. And that is now being taken under consideration in the Green Paper policy. So it's not only about the music, but it's also about the movement. And we will have an opportunity in our discussions on the Green Paper, the policy on culture, entertainment, and the creative sector. We'll have an opportunity to all make our inputs in that. During Reggae Month, we also use the opportunity to build capacity. So you have an organization for the different sectors. And in having those organizations for the sectors, we help to build capacity. So, for example, to be registered on the e-registry, your sector organization must sign off on you as a member, so that there is more structure to the sector. Noise abatement, that has always been a sore issue. We do not have as much pushback right now from the police, from the JCF, and we are working together. They hardly turned down an extension that I signed. And we are working on regularizing, but it won't be the noise abatement. It will be the sound regulation legislation, right? Because music is a noise, right? So we feel strongly that it should not be referred to as noise abatement, but rather to treat with the sound regulations. Entertainment zones, I'll be announcing shortly some of the areas that are going to be designated. We have started, for example, Olympic Way is coming up, right? There are some locations, because there is an issue with parking, like Sabina Park. We're trying to work through that. If you have in your constituencies areas that you would want to recommend as an entertainment zone, please provide us with the information, and we will deal with it. The original organizers of Dancehall Week, they are very much a part of the team with Ramesh. What we're able to do was to bring them together so that Dancehall Week and the activities could be more organized and have stronger support, even in terms of the finances. Now, somebody mentioned PANED. I used to manage PANED. Yes. And the local promoters who are doing the events, as I said earlier, I would want you to reach out to them. I'll provide a list, parish by parish, so that you can reach out to them and identify with their activities. I don't know if I can find funds or if I will be able to convince anyone to provide, you know, a little seed fund to help you to build the spirit in your constituency, but that's an effort I will, right? And then, although a number of things are being held in Kingston, there are things happening outside of Kingston. And the activities that are national will be streamed, including the symposium. So it means that persons from across the island and even in the diaspora will have a chance to participate or to observe what is happening. So those are my closing remarks. Thank you so much. I want to see all of you at the events. I'm inviting all of you to come to the events, all my colleagues. Right? And Minister Samuda was at the launch, and the launch was fantastic. Minister Morrison, Minister of State, she was at the launch. We had, you know, in the business, when you have standing room only, it means you sell off. Right? And it was a really successful event. Thank you so much, Mr. Speaker. Thank you, everyone.
Mr. Speaker, as we are closing, let me just join with the members who have urged the acting Prime Minister to exercise her authority and to take reggae vote to the people in the constituencies. Mr. Speaker, it is not intended to do any further business today, but let me encourage the members to turn out for the 3-day workshop being hosted by the Commonwealth Parliamentary Association and Parl Americas. I know even if you are not able to make all the days, please start tomorrow. We have a slate of persons from across the globe, right here in the Caribbean and in the UK, who will be going through parliamentary procedure, financing, post-election workshop and training. So I encourage the members to attend. Mr. Speaker, we now ask for the adjournment for a date to be fixed.
I too want to add that we are encouraging every member, especially those who are in Parliament since September for the first time, that you make every effort to be at this seminar over the 3 days. Please, it is wise that you try to be in attendance. So at this time, the motion is on the floor for the adjournment for date to be announced. Those in favor? Those against? Ayes have it. The sitting now stands adjourned.